Now, that's the part of the ordinance that we're going to call the general framework. This is the general subsection. Oh, come on, you stupid thing. All right. All right.
Hey, Eddie, I just want to say I definitely appreciate you and what you're doing.
Well, thank you. Let's see. You know, that's not going to work because for some reason this stupid thing is trying to justify it. But okay. All right. For now, we'll change the way this is done and do it this way. All right. All right. This is why I hate Microsoft Word. Nope, not at all what I fucking asked you for. Stupid thing. Okay, anyway.
Tell it what to do.
Unfortunately, it doesn't just tell, it's
Got a Fonzie it.
Personally, out of all the cases that I'm dealing with, Microsoft is the worst part.
all right. Now, just for the everybody, let me see, can just so you can tell the difference between my outline and the ordinance section. Everybody can see the yellow highlight, right?
Yeah.
Okay. The yellow is taken straight from the ordinance. The first thing I do is I will take the ordinance or the statute and I will break it down according to the elements it's got in it. And I will do it section by section. The general section is at the very top of the ordinance in question, okay, which is 6-80. So the owner of any animal in the city is responsible for the behavior and conduct of that animal at all times, including conduct that creates a public nuisance. A person commits an offense if by act, omission, or possession, he or she allows an animal to create a public nuisance. The following are public nuisances. So all we need to take away in this section is what's in the first sentence. Okay? Owner of an animal, owner responsibility for the animal. That's what this says right here, right? The owner of an animal in the city is responsible for the behavior and conduct of that animal at all times. So, owner of the animal, owner responsibility for the animal, right? Everything else goes to the following public nuisances, which is everything down here in 680E. Okay? So, and I don't know why. Let me pull this back up again. A person commits an offense. 1, 2, 3. All right. Person commits an offense. That. We don't need these. And all right. A person commits, and it should be an offense, but still. In a manner of that, and then it's got the 1, 2, 3. All right, so that can go. That's the ordinance on the second part. So let's break this part of the ordinance down. A person commits an offense if, okay, and the first thing here should be intentionally feeds.
Go ahead and
Yeah.
throw willingly, intentionally, willingly, and knowingly.
Or makes food available for animal consumption.
I guess I'm guilty because I intentionally put out my trash that feeds the raccoon every Monday night.
All right, now notice how I'm doing this. If we take the first part of this, the person commits an offense if the following action occurs. He or she intentionally feeds any animal or makes food available for animal consumption. Okay. That should be and in a manner that. Okay. And again, and because making the food available for animal consumption in a manner that the language says the following must occur. One or more of the following must occur. The manner of feeding must result in one of these following things. Got it?
Yeah.
So then we break down the following things, which, again, I don't know why cutting and pasting from a freaking PDF is such a royal pain in the goddamn ass.
At least you caught it.
Yeah, the thing is, copy text. Let me try this again. Okay. Now, let's just make that its own list. All right. And we'll put it over here so it's separate. Okay, now. So we have this part, and we broke it down into these three parts. Okay. Then we have this part, creates a danger to public health or safety. We broke that down into these two parts, creates a danger to public health or creates a danger to public safety. Okay. Now you see the ors and the ands on the end? That
Yes.
tells us whether or not the next condition has to be met along with this condition or is optional.
Question about that.
Okay.
There's a statute in my state that says both words can be read either way.
There are some statutes that can be read either way. Okay.
Well, no, I mean the statute itself says and can be read as or can be read as and. Yeah, so how do you get around that?
Well, you don't if the statute specifically says it can be this or that. But what you would have to do in that case is you'd have to challenge it as being vague, ambiguous, or overbroad, because and cannot and does not ever mean the same thing as or. They are mutually exclusive. One ties them together, the other splits them apart. So if you have a statute that says exactly the opposite of that, well, then that statute's unconstitutional because it's vague, ambiguous, and overbroad, because it can make the offense applicable no matter what the conditions.
Thank you.
Hey, Jack, what state are you in?
And I'd be really interested in knowing that as well. Not only what state, but what's the statute? Give me a link to that statute.
That's Ohio, and I'll put it in the chat when I find it.
State of confusion.
Okay. So let's go back up here and let's say that we highlight this one. We leave it yellow. Okay. And then we come down here and we highlight these three yellow. Now let's go to the first one and let's highlight it a different color. Let's highlight it green. Okay.
All right.
Then right here, we highlight both of those the same color because we split that one into two parts.
Mm-hmm.
Okay. The next one, let's highlight it a different color. We'll make it blue. And since we split it, why didn't you do the whole damn line, you stupid thing?
Yeah, you tell it.
Okay. And then this one, we also split into two parts, public or private property, right?
Mm-hmm.
Okay. And this should actually be now. Let's make this one its own color. And it should actually be like that because well, sorry. Yeah, no, that's right. And okay, why are you doing that, you stupid thing? Okay. All right, so this one should all be gray. Okay.
3, 4, and 5. Yeah.
And that's how we broke it up down here. We broke it up into its individual pieces. So 2.
Do you file it that way?
No, this is for you to start writing. Okay, so that's how it reads in the actual ordinance. And this is how we broke it down. Okay, so now you write from your outline. This is our general framework of what we have to address. This is our specific subsection we have to address. And this one here should be, God, I hate this dog. Okay, specific subsection. Okay, and specific sub item. All right, so My outline breaks the ordinance or the statute into three specific parts. If there's a general section, that's in one part. If there's a specific subsection, which in this case would be the 6-80E portion of the ordinance, okay? And then below that are the individual sub items beneath 680-E, which is 680-E1, E2, and E3, okay?
Mm-hmm.
And then we color code them and we go from there. So these three things would actually be addressed in this section right here. Okay, this 1, 2, and 3 that's yellow down here would be up here with their yellow text. The green would be with its green here, the blue with its blue here, et cetera, et cetera. But you make an outline like this. This tells you what you have to address in your legal pleading. Okay, these are the specific factual points you need to argue about and write about. This is your base outline. Okay, so using the base outline, let's open up another copy of Word and another document. Let's put these.
Shut everything in the house.
Could you write this up similarly to if it was in federal court, if you were making a claim?
The difference here is a lawsuit if you're making a claim versus a criminal defense pleading. Those are very different animals. But yes, I would still want to write down an outline of what I have to assert to make my claim and what I have to prove. For instance, if you're going to prove breach of contract, there needs to be specific information about the contract, what part of the contract got breached, how it was breached, why the breach is relevant, and why you have damages resulting from the breach. Those would all be different sections of your motions to make a claim, wouldn't it?
Yeah.
Yeah.
But something interesting too, just on this quick, is that when you start getting the aspects of being able to just prove whatever you need to prove, and the elements like you said, like simple notice and demands will get results as well. Like just recently.
Notice and demand won't get you anywhere if you don't put specific facts in it that makes the other side take pause and go, you know what? They may have a claim.
Yeah.
If you just say, I want money and here's why, and you don't give them anything to base the legality of your claim on, they're going to ignore you like you're not being realistic, like you're just some joker.
Well, if I give just like a quick example, earlier, 2 months ago, or actually, the month of June was actually paid for me for free. I'm with a rental company and the refrigerator went out, and it took them almost 3 weeks to get the refrigerator replaced. Well, I can easily make a claim because, of course, I have to go out and spend more money because we don't have a refrigerator that works.
Well, that depends. What is the contract agreement on turnaround time for replacements if the rented unit goes out? What does the contract say?
Right.
The fact that you spent money is irrelevant if you don't have a legal basis for making a claim why that money needs to be reimbursed. Correct. If there's nothing in the contract that says they have to replace it within a certain time frame, then they can make a multitude of arguments to say why your claim's invalid. Well,
correct.
It was out for 2 weeks before he even called us. So it's not our fault he had to throw all the food out or get something to replace it before contacting us.
Correct.
You see what I'm saying?
Yeah, but then again, even if it's not explicitly stated in the contract, you still got like federal housing laws and things like that are
housing's different than appliances.
No, I get it, but it's all in the aspect of rental. Like if I'm renting something.
No, it's not all in the aspect of renting. There are different criteria for the type of rental. You can't say that it's a generic framework. It's not. There are certain things you can rent that follow different rules than other things you can rent. Homes being different from appliances being different from moving vans, and all of them being different than livestock or breeding stock or materials or goods or services for that matter. They're all going to fall under different statutory schemes different rules, different requirements. The only thing you can rely on from the get-go is what is in the actual contract, period. Everything else then becomes an issue of arguing the law, not opinion. So you've got to be able to have some framework to compare those two things to: the contract, the law governing the contract, period. And you cannot ever say they are the same, especially when the subject matter is different. Now, you can try to make an argument that they should be looked at the same way based upon this criteria, but that's an argument. It's not the law and it's not the contract. It's simply an argument. You understand the difference? Hello?
For sure, for sure. Yeah,
Okay.
I was just gonna let you know too. I threw the what I did to get that free rent just based on the refrigerator. It's that last link to overleaf.
Yeah, now they may want to keep you as a client or a customer, and they might agree to do certain things for you and give you certain amenities or do certain whatever that they wouldn't contractually be required to do.
Well, it was just under revised codes of Washington, landlord tenant, statute. That's really all it was.
Okay. And they could have very well went along with it just because, well, we want to keep him as a client, don't argue, just do it. But that doesn't mean if they decided to fight it that you don't want it in court. So that's the part I'm trying to get you to understand. Never take the fact that something worked out in your favor as absolute proof that you did everything right.
Oh, yeah, for a fact. Yeah.
Okay? There could be a million different reasons why they just said, screw it, do it. Okay? And the biggest problem I have out of patronuts and patriots is that's how they base their success. Well, it worked out for me. Yeah, but what evidence do you have that what you did is the reason it worked out for you? Rather than them simply going, I don't have time to screw with this. Just get him out of here. And they never even looked at what you did or considered what you did. And now you're going to rely on it in every case that follows? That's stupid.
That's a good perspective.
You can't, until you have a signed order saying, this is why you won, everything else is speculation.
Facts.
So for a federal claim, like for a 1983 claim, for example, don't they have to have elements as well?
Every claim has to have elements.
Okay.
There has to be elements of what the claim is, why you have a claim in the first place based on those elements, and what the elements are for relief for making such a claim. Everything's got elements. For instance, one element of compensation for a particular type of claim is how much money. Is there a minimum and a maximum? Is it unlimited? Is it limited by certain other criteria? All of those constitute some sort of element of one category of the case, whether it be the offense, the cause, the relief, whatever.
Okay. I guess I get confused sometimes when I read through what people have filed in previous cases.
Okay.
They explain what
document-
happens.
Yeah, the document you see right here, everything that I've got highlighted, what you have is the language that contains the elements, which is the major stuff in yellow out of the ordinance. That's what contains the elements. And then this right down here, this 1 through 11, is our breakdown of those elements. So we know that there are 11 specific things that if they're trying to hit us with something, in Jane's case, they're trying to write the complaint in a way that says they can try to prove any of these three things. Instead of saying, this is what we're charging her with, they're going to try and take 3 bites at the same apple. And they can't do that. So
Yeah,
what
don't
we
they have
did
to
was
prove all
follow,
elements?
they would have to prove every single element of, they would have to prove all 11 of these elements to convict her of all 3 of these things. The problem is they don't have proof of even one. And they know it. But they're trying to prosecute her anyway.
Gotcha.
Okay. So what we need to do is to address the intentionally feeds any animal. Okay. How is intentionally defined? We don't know because the statute or the ordinance in this case doesn't define it. So what is required for there to be intent? Okay. Well, in this case, the intent has to be tied to this element right here. You intentionally fed an animal or any animal in a manner that. Same thing applies to the second element. Made food available for animal consumption in a manner that. You get it? 1 is tied to 3, 2 is tied to 3. So they have to prove the intent was to do the feeding in a manner that resulted in one of these other things right here. Okay? They would have to prove that and then all of these other things. That's why there's an or here. It's either 1 or it's 2, and then everything else is in the manner that, and then it can be created a danger to public health or creates a danger to public safety. Why is it an or instead of an and in these cases? Right here. Why are these all ors?
Isn't that like one after other? You can be doing that section by doing this.
No, it's because the ordinance
Like in
specifically
connection.
says creates a danger to public health or safety. So creates a danger to
one or
public
the
health
other.
or creates a danger to public safety, right?
One or the other.
Exactly. And then you've got or, since there's a 1 and there's a 2, 1 is separate from 2, right?
Yep.
Yeah.
Okay, so
yeah.
destroys public property. And here it just says destroys public or private property, right? So it's destroys public property or destroys private property, right?
Yeah. Loud and clear.
And then it says causes more than 10 animals to congregate in one location at the same time. How many elements do we have here? How many elements are in that one sentence on number 3?
6, I think.
Seven.
Well, technically, the ors could be either or.
Okay, wait a minute.
So,
Wait a minute. He said 7. Tell me what the 7 are.
Creates a danger, destroys public property, maybe.
No. These are different. We're only talking about number 3 here. This one right here.
Oh,
How many
okay.
elements are in that one single thing?
Count 7. Under
Count
3.
7. Tell me what you think they
Yeah.
are.
Isn't it just 2?
They're numbered right there. That says
10, there has to be 10 animals, and they have to congregate at the same location. Oh, actually 3 it would have to be at the same time.
Oh, the just in 3. Okay.
So how many elements are there?
3.
Wrong.
Oh, only
4.
1.
Okay.
There are 5.
What?
Causes.
they're
It
they're
must,
highlighted.
the following thing must happen. causes. Okay? Isn't that the first word? Causes.
Okay.
What does it cause? More than 10 of something. Right?
Okay.
Minimum is 11.
Okay? So more than 10 of something. That's the second element. Third element. Those 10 somethings must be adult animals.
Oh, wow. Okay. I just didn't.
And those adult animals must congregate in one location. Now, location is not defined. Doesn't tell us what constitutes a location. Can it be does it have to be within a circle of 10 feet? Can it be anywhere on an entire acre of land? Can it be anywhere within the city limits of Irving? Is that a location? We don't know because the ordinance doesn't define what a location is.
Yeah, that's ambiguous.
And they must do so at the same time. Those are the 5 elements in that one piece of the statute. Technically, you could divide each one of these down as well. Okay. You could break that one down even further in a manner that creates a danger to public health. Right? So you technically could split that one into 3 separate things as well. There must be a danger. It must be to public health, and the actions created it. Right?
Oh,
Yeah.
oh, okay, now I'm seeing it.
I'm loving this.
This is exactly how you have to learn to break down and read a statute. Okay. Same thing here. Let's take this one. The action must be destroys. And it must be public property, or it must destroy private property. However, there's another problem with the ordinance. It doesn't define what is public property, and it doesn't define what is private property. And even more importantly, it doesn't differentiate whose private property. The way the ordinance is written, the person being charged with the offense, if even their own private property was destroyed by the animals, they can charge them with this offense.
But you sitting me? What?
No, the way it's worded, because they don't define what is what constitutes private property or whose private property, some third party. It never says third party. It just says destroys private property.
That's ambiguous.
Yes, which is the challenge we made to the whole fucking ordinance. The entire ordinance is vague, ambiguous, and overbroad because it doesn't define any of the fucking terms it uses.
It's also unconstitutional.
Well, that's exactly how we're challenging it. Jane, would you have a problem sharing the motion we filed for you with these guys?
And they
I
want to
think she's on
prosecute
it.
anyway.
Is Jane still on here?
Yeah, last I checked, she wasn't.
She gone.
Yeah, she's out
She's
of
been
here.
gone for a while.
That's the problem. Jane
What
gets
has been
upset and
surprising-
mad at me because she doesn't listen to what I'm asking her. Now, I don't want to pick on Jane. I don't want to start that, but I do want to ask a question. Was I being in any way unfair to her asking what I was asking and saying she was not answering what I was asking?
No.
Now you're
No.
being Texas frustrated.
Yes, that's exactly what I get. But see, this is what I keep telling you is that I treat you this way here so you get used to it. Because
Yeah,
they're not
sure.
going to treat you nice in these courts. Now, they may be as sweet as honey, but I guarantee you they're waiting to stick a fork in your ass the moment you're not looking and paying attention.
Mm-hmm.
Sheep to the slaughter.
Okay? So you better pay attention.
If they can't handle you, then they won't be able to handle a courtroom.
There you go. That's exactly what I tell everybody. If I scare you, piss you off, or make you afraid to open your mouth, they've already got you by the balls or the short and curlies, whichever one you happen to have.
I like that.
Mm-hmm.
So,
Yeah, court's not for snowflakes. Just get an attorney.
all right. I'll tell you what I'm going to do.
The biggest thing that frustrates me is how she was yelling at you. I mean, that pissed me off.
Yeah, she gets upset. Okay.
And you should take it personally when you question what she's done instead of trying to learn from it. She wants to defend herself from like having done something wrong.
Right. And,
And
she gets defensive. That's what I say. When she gets defensive, that's the indication that she's taking it personally.
Right. You can't take it personally. I mean, you get what an
Mhm.
opportunity to learn here. And you
Exactly.
and say, okay, I screwed that up. How do I fix that?
She's paying you for your expertise, and you're going to argue with him? What the heck?
This is a pretty cheap education, law education. And I don't think you charge enough for it, quite frankly.
Honestly,
I don't think I do either, but you know. All right. Can y'all see these files easy enough?
Yeah.
Yeah.
Okay. This is all the paperwork. I'm gonna tell you what we have here so you'll know what you're seeing when you see it. I'm gonna zip these files up and I'm gonna stick them up on the public drive that there was a link in the email to. Okay. The public information folder, that's where I'm going to put this. This is Jane's case, and I'm gonna put I'm not going to put the reports that's got her actual home address and everything in it, which is all these down here. But just so you know how I name my files to organize them on my hard drive, the DE is defense exhibit. Okay. DEX, defense exhibit. And then the exhibit number, D03, D01, D02. Got it?
Okay.
All right.
Yeah.
Now, the 9-9s. These are discovery items, things that are provided in discovery, 99D. Okay. And then an item number for it. That's what the other side provided to us. Okay. And 99S. 99S is communications from the court. Okay. They're not your evidence. They're not an exhibit. They're simply communications sent to you from the court itself, like hearing notices, et cetera, et cetera. Got it?
Yep.
All right. Everything else is written according to the order in which it occurred. Right here, 01.01. That is the initial complaint. It was the very first thing, which is the first 01, and the very first document. Okay, so 01.01. Then a clear, unambiguous name of what the document is. Okay. Then the next document that was put into the court file was by us. So it's 01 in response to the first document, hence the 01. And then it's the second document filed, 02. Got it? Their complaint, our motion to about that complaint. So, respondents, motion to quash or set aside 01. For complaint number, same as what was on the first file. Got it? And this was our first original motion. And then I always put a version number on my documents when I'm writing them. That way I can save a new version, make changes, and I can go back to a prior version without having to rewrite shit or Control Z shit. You got it?
Yep.
You'll wind up with a lot of documents if you're not careful. But what you can do is you can make a revision folder. And what you can do is as you're making a new version, copy the old version out of the folder into the old to the revision folder. That way you still got it, but it's not in the middle of all your files so that you keep clicking on the wrong one and going to it. It unclutters your space. All right. Hang on just a second. Boys, lay off. Cap, leave your brother alone. Sorry. My border
Yeah, you're
collies.
good, man.
One of them
we get it all the
is-
time with Cameron on him, man. His
Yeah,
daughter's
mine's
interrupting and whining, and yeah, man, it's all good.
Yeah, my
Father
border
first,
collies. I got 3 male pups from the same mom that I'm keeping them for breeding. But one of them is definitely the alpha, and the other 2 like to say, "Get out of my face," even to him as an alpha. So that's what the growling and all that shit is about, that I have to turn around and break up because I'm the real alpha and they know it. All right. Now, just so you know my abbreviations, MQSA, motion to quash or set aside. That will only apply to indictments, informations, and complaints. Motion for sanctions, MFS. I filed a motion for sanctions against this city attorney for doing the shit she's doing. MCSMJ, motion challenging subject matter jurisdiction. Okay. And then we have the City of Irving's response to our MQSA 01. So everything that's in the same batch stays together, that they're all numbered 01, which is why all these have that number. This is everything that was filed by them originally, us in response, and then if they respond, it's still directed toward that same series of pleadings. Everybody understand?
Yep.
You're free to organize this any way you want. This is just how I do it. All right. This helps me keep everything in chronological order as well. That way, if I go back and make changes and the date modified changes, or the title changes, it doesn't resort the document from where it was actually filed. I can keep track of everything this way. I know each one of these documents came one after the other because of how I numbered them. You get it?
Yeah.
Yep.
All right. So they amended the original complaint, this document, and refiled it. So we started a new section 02. This is now their second complaint. So we went from first original to first amended, but it is in reality the second complaint because they withdrew the first one and filed a new one. Got it? But it is the first amended of the original, hence the reason it's in the name that way. Then we have our response. Then we have their response. Then we have a new complaint. The city attorney keeps saying the complaint is valid, yet she keeps withdrawing the complaint and filing a new one. She keeps saying that the arguments I'm making don't apply. She's following the statute, and yet her actions say he's right and I know it, because she withdraws it and she files a new one. She's playing games, but she's also realizes something else. She's fucking losing. When you make the other side withdraw a document, they lost and they know it, or they wouldn't have seen the need to withdraw it. Right?
Yep.
So she knows the arguments we're making about the complaint are 100% dead on. She's trying to argue in her responses that they're not, but she's withdrawing the complaint anyway. She's basically admitting to the court, they're right and I'm wrong. And the court's not doing anything with that information, despite us telling them they need to. So again, they filed a second amended complaint. So when they do that, it starts another series again, 03, because now we're on our third complaint, our third iteration of the complaint. But it's still an amended complaint, except this time it's the second time they amended it. Now get this. This is how stupid the city attorney is. The second complaint was reverted back to everything that was in the original complaint that was all wrong. He basically refiled the original complaint for the third time, and I've just refiled my first response with some additional information saying, here's why the city attorney's a fucking moron and walking you guys into a fucking malicious prosecution lawsuit. And I did not hold back on her whatsoever.
How can that not be malicious prosecution when they?
Oh, the thing is that she knows it's malicious prosecution. Okay. And then we have our response to their response. Okay. And let's see, what did I actually title this one? I'm sorry. This was a motion for change of venue. I was thinking of filing a motion for change of venue to move it out of this municipal court, because if that judge responds incorrectly to our third motion here to quash or set aside, then we're going to move for a change of venue, because it's obvious this municipal court judge is not going to be fair and impartial. This is what she should have filed or would file instead of a motion to disqualify or recuse. When you have the judge dead to rights, acting biasly against one of the parties, then you file to move the fucking case, because you can't get a fair trial in that court.
If I may.
Yes.
Article 3, paragraph 2, section 2, when the state is named a party, the Supreme Court has original jurisdiction.
I agree, but the state is not named as a party in a civil suit.
Oh, I didn't hear that. Okay.
Okay. This is a criminal case.
Okay.
All right.
I thought it. Oh, my bad. I was gonna say, I thought this was criminal. I said,
yeah, this is. They've got an ordinance that they gave a criminal penalty for. So this is tried in Texas as a criminal case. All right. Now, so what you need to understand is I'm going to give you guys copies of the pleadings. All right. I need to turn the magnifier off here.
Yeah, you were talking about Title 28, Section 455,
okay.
4B, 4B bias.
Now, what I'm going to do, you're not going to get any of the reports or the defense exhibits or anything like that, because they contain Jane's personal information. All right. But I don't think I didn't write any of the pleadings to have it. I don't know if any of the ones she filed has it, but none of the ones I'm giving you are hers. They're all mine. Okay. So the actual pleadings and their responses to the pleadings and the complaints they filed, I'm going to zip these up and I'm going to put them in that public folder. And you guys can download and take a look at it whenever you want. Okay.
Thank you.
And what you just do is you look for a file named Jane-Irving Animal Control. That'll be the name of the file in that public folder. All right, let me close all this so I can get to where it is. And my drive, public folder, Jane Animal Control Irving. All right, and just in case that for whatever reason y'all don't get it in the email, here is the link of the Google Drive folder where that file is now located. So here's what you need to do. When you unzip this, they'll all be in the same order I just showed them to you. Okay. So start at the very first one, read it. You need to read it because you won't understand why I challenged it until you do read it. Okay. Now, the other thing that I forgot to put in the zip file is this. Okay. Now, she made references to the ordinance and to the Texas local government code in her responses. So there are the 3 PDFs that contain the information that the city attorney referenced as the basis for why she could do the thing she's doing. The problem is when you read my pleading, you will find out that she's making shit up.
Rule of lenity.
Okay. So copy those 3 PDFs. I just dropped them in the chat for you guys. Download those and put those in the same folder where you put this archive and unzip it. Because you will need to go and look at those to see exactly why my pleading says what it says. All right. Now, here's what I would like for you guys to do for the next class. If you wish to come back, you have the link for the entire schedule for this month. Okay. The link that's in there gave you the whole schedule to import the class schedule into your calendar. However, normally only the first class of each month is open and free to everybody. The other 3 classes are by subscription only. This month was special because we're trying to get Jane ready for trial. Because we're doing that, we're going to conduct a mock trial at the end of the month. So I wanted as many people as possible to be there to participate, to learn from that experience. And in order to do that, you needed to understand how we got to that point. Hence, I opened up the month for everybody. Okay?
Did you
So,
say,
go ahead, Julie.
I'm sorry, my headphones got unplugged and I didn't hear everything. Did you say you're dropping 3 files into the chat?
There are 3 files in the chat that should have went to everyone that are the City of Irving ordinance, the ordinance itself, and the definition section from the ordinance, and then chapter 9 of the local government code. Those are the 3 PDFs that are in the chat.
Okay, can you do me a favor? Can you check to see if they're still uploading or if it's okay?
They're all right there.
Okay, I got it. Thanks.
I said I dropped them in the chat. I didn't say I'd sent them yet. I wanted to make sure I wasn't missing anything else before I did.
Okay, I'm sorry. I misunderstood.
No, that's okay. That's okay. All right. So download those 3 PDFs and then go download the zip file out of that public folder link that's right above it, right above those 3 PDFs. Okay. Now, who wants a copy of this Word document on how to break down that ordinance?
Yeah, I would like that, please.
I would like that, please.
Yeah, I would love that. It's a great tool.
All right, I'll put it in Jane's folder just so I can always find it again. Let's see.
Oh.
All right. All right. All right. That Word document is also in the chat.
So you're asking to learn Jane Irving animal, right?
What's that?
Unsupported. I was trying to find what you wanted us to study. Jane Irving, Animal Control.
Yeah, James-Irving Animal Control.
Oh, that's zip. Okay. It said unsupported. Finally found it. Took me a little bit, but I found it. Loading and
What operating system do you have?
unsupported.
What are you loading it
phone.
into?
Probably Drive or something. I'm mobile.
Okay, it's a zip archive. So I don't know if you have something that can do zip files on your mobile device. Usually it's built into the OS. That's why I made it a zip file instead of a RAR file.
Gotcha. I'll try what I can.
I mean, I don't know. Let me see if it's.
I'm gonna go in my Drive. See if it downloaded into Drive.
Let me see if it'll
Thank you,
fit in the
Worcester.
chat. All right. It's also in the chat. The zip file
Okay.
is also in the chat now.
Open other app. Previewed in the Zoom. Dang. Didn't work for mobile.
All right. Everybody get all the downloads from the chat. Speak now, forever hold your peace.
Yeah, thank you for that. Didn't mean to push
Pretty
your
sure I
buttons
got
on it. Didn't mean to push your buttons on it.
No worries.
I'm also on mobile.
Y'all should have one link and 5 downloads. All right. Anyway, back to the homework. Go through these documents in the order that I've got them. Understand the argument that was made from both sides. Now, here's the thing. In order to become a good pro se litigant, you've got to learn the same way that attorneys learn. And that is how to argue both sides of an argument. The for and the against, just like in debate. Now, we've all seen YouTube videos where a lawyer goes to court to make an argument for a case. There is no fucking way in hell that attorney can possibly win or should win. But they're up there trying to make an argument, no matter how fucking asinine and ridiculous, about why they should win. Okay? You need to play devil's advocate against yourself when it comes to reading each party's documents. Pretend you're the city attorney and you're trying to win when you read hers. Pretend you're the defendant and you're trying to win when you read ours. Okay? Understand the perspective. That will teach you how to counter that perspective on the fly in real time. Because you have now learned how to think like the other side thinks. What would I be doing right now or in response to this if I were them? How would I deal with it? What would I be trying to deal with? What kind of argument would I be making? Why would I be making it? How do I support it? How are they going to come back and argue against it? These are all things that need to be running it through your mind in real time. And you need to be prepared for it. This is why I tell everyone that comes to this class, being an attorney, a courtroom attorney, one that actually goes to court and argues cases, is a very difficult job. And it takes a very specific mindset to do it well. This is exactly why in big law firms, there are only a handful of actual litigation attorneys in any given law firm. Okay? There are people who are good at research. There are people who are good at writing documents. There are people who are good at interfacing with clients. And then there are people who are good at arguing on their feet from what's in their brain. And they are not always the same person. If you're going to be pro se, you have to be all of those things. And not everybody's going to be good at it. You may be good at one thing and completely suck at the other. And you may get past that or you may not. The key thing is can you recognize which one it is before it's too late?
I don't know how Cameron did it. Like I guess he just went and made friends with the prosecutor. And then when he went in, sat down for less than 5-10 minutes, and administrator said case dismissed.
Well, again, without being present or having a transcript, I couldn't tell you either.
Well, he just made friends with the court.
Well, there's nothing wrong with being a likable person. You want to be the most likable person in that courtroom, especially if you're doing a jury trial. You want them. Okay. You ever heard the whole old joke about what is a trial?
No.
A trial is a play to see who the jury picks as the best attorney. Okay. It's kind of like the best actor award for a movie.
Oh yeah, best actor.
A trial is a play where the jury tries to decide which side's the best actor. And you want to be the most likable actor in the room.
Yeah, Cameron Wilson is pretty likable for some reason. Guess the prosecutor liked him and judge just saw it in his favor somehow.
Well, again, he also may have made some very valid legal points in his own favor.
Yeah.
Okay.
And
you can't discount that possibility either.
And just dismissed on his merits and didn't tell him why.
Now, you want to know the ones that I immediately discount? If someone goes into court saying, I'm not a corporation, I'm not the straw man, I don't work for you, the Queen of England said, the Postmaster General said, the Pope is the guy who rules all this, and he's the only one that can sit where you sit. Those are the ones I immediately get up and go, well, this shit ain't going nowhere, and I'll go home because there's nothing interesting to see here, except for the beating that's going to soon follow if this person keeps carrying on in front of the court this way.
Yeah, wasted argument.
Okay, now let me tell you a little bit about me on why I'm that way. I spent a great deal of my time over the 20 plus years I've been doing this, disproving all of this shit and showing very straightforward, logically and statutorily and case-wise why it's dead fucking wrong. Okay. One of those things, for example, is the state national bullshit that's being promoted by so many people.
No. Yeah.
Now, all you have to do, and they cite a very specific federal statute as the basis for making the argument they're making. But you know what I know about that statute? First and foremost, is not a one of these people quoting it I've ever fucking read it. And if they did, they damn sure didn't understand it. And you know how I know that?
Curious.
Because they're still making the fucking argument. See, every statute, no matter who wrote it, with the exception of a city ordinance in the case of what we're dealing with in here, when they use terminology, they generally have a definition for it somewhere that tells you exactly what that terminology actually means. And it may look familiar. It may sound familiar. It may look exactly like a word you have read and seen 1,000 times using common colloquial English when you're talking to somebody and reading a regular dictionary and you think you know what it means.
Right.
I guarantee you when it comes to reading it in a statute, you do not know what the fuck it means until you go read the statutory definition for it. Because there are two rules that are irrefutable about a definition for a term in a statute. Number one, if a statute provides a definition, then it is a 100% guarantee that term does not mean what you think it means because it is not the common and ordinary meaning that applies. If it were, there would not have been any reason for the statute to create the definition. Therefore, if it's in there, then its meaning is not the one you're familiar with in regular everyday usage. Period. Number two, the other thing about the definition. It will contain other words that also look familiar. And it will contain other words that themselves have a separate definition of their own. Those are called what I refer to as compound definitions. In other words, I have a defined term, but that definition for that term contains several other terms that also have separate definitions somewhere in the statute, either above or below in this same section or defined by the statute somewhere else. And I've got to find it before I'll actually be able to read the statute correctly. And that's where everybody screws up. And that's exactly how they screwed up on the state national bullshit. They thought they understood the words because they saw the word state. Yet in that statute, state does not mean state of the union. Never did. Never will. State means something completely outside of the several states of the union. So does United States. Okay? So everything that's written in that state national statute deals only with people that were never, ever citizens of any of the several union states. Word to the wise on federal law. If you see the term United States or the word state, you better not accept it as its default meaning to you. Guaranteed, there will be a meaning somewhere that's defined, and it will be different or contain something else that's different from how you commonly understand it, which means it's a different definition entirely. And you will be reading the law wrong until you understand the correct definition and what it is.
Doesn't it mean the District of Columbia?
Not in every case. For instance, state can mean, usually state means the District of Columbia and all federal enclaves, territories, and protectorates. That's what state means in federal law. Doesn't mean the several union states, okay? And that's normally, if it does include those, that's exactly how it will word it. The several states or the several states of the union, if it's actually talking about these states. Otherwise, it's DC, enclaves, protectorates, and territories, which none of the states are. That would be like Guam, Puerto Rico, the Virgin Islands, Washington, D.C., the Panama Canal. Okay? Those are all federal territories, enclaves, and protectorates. So when you see state, that's what you need to think of first, not the states of the union, unless state specifically says any state of the union or of the several states. And do you know how many different definitions I've uncovered in my time studying federal law for the term United States?
Hundreds, probably.
You're probably as mad as Willy Wonka.
There are, to my knowledge, 26 different definitions for United States or United States of America. 26. Man. That's not saying there's all of them, or that is all of them, but it's how many different ones I've encountered. And believe it or not, some of them are within the same code. It's like the transportation code here in Texas. The term motor vehicle is defined 4 different ways depending upon which chapter you're reading.
Yeah, in Oklahoma, it's defined around the same amount, 4 or 5 different times. And they all use the same language. It's a compound definition, like you said.
Yes, everything's a compound definition, and you need to look for every term in there to see if there's a definition for it before you trust your reading of it. And like I said, this state national shit, nobody bothered to do that. Nobody went and looked at the definitions. Hang on just a sec. That's something else I want to give y'all so that you can understand the argument. All right, actually. Everything.
Eddie, if I recall, the plain meaning rule. Refers to the plain
The
meaning
plain
of
meaning
the
rule will apply only if there is no statutory definition. Okay, remember there's a hierarchy to determining what a word means. Okay, there's a hierarchy. Do you know what it is?
I do.
federals first and then
No,
lower courts
that's
after.
Statute
jurisdictional hierarchy.
Statute first.
What statute?
And then if it's not defined in the statute, then it's Black's law.
Wait. What statute?
The one you're
Statute
being
that deals
charged with.
the specific thing you're looking up.
The
So,
definition.
for example, in the
If you're looking up
animal
for a
case,
definition
the
in the statute, you
statute.
gotta find it in the statute first.
the-
All right, something. I know I have this in here somewhere. Actually, that may be in that public folder. Yeah. It's in that public folder. State National 8 USC 1101.
Cool. Thank you.
Everybody see it?
Yeah.
Yep.
You need to read that. Okay, so again, that's your assignment. A lot of reading between now and next Thursday. But in the reading, understand the arguments that's being made from both sides. Okay, come with questions. Whatever you have a question about, write it down. Bring it with you to class. And when you write it down, document why you came up with that question. For instance, if you got it out of a particular document, what page and paragraph in that document you got it from, so we can go to it really quick and easily. Okay, that'll help speed the class up, make answering the most questions in the shortest amount of time possible. So get your questions out of what you read. Make sure you document where the question came from and why, so you can ask it correctly, and be prepared to discuss your thoughts on it. Part of this class is learning how to think like a lawyer. And that requires you to be analytical, critically thinking and analytical. Okay? It's a forgotten ability nowadays. Sad to say. Critical thinking doesn't hardly exist in the common individual anymore. So part of what I'm going to try to teach you to hear is how to learn how to do that again. And that's exactly why I break down things the way I do before I start writing about them in these documents. I'll usually have 5 or 6 copies of something on the fly, because I'll write down a bunch of shit and then I'll go, okay, now how do I condense this? How do I take the prime concepts of what I'm writing about and put it into minimalistic but clear language, so I can then make the documents as short as possible, but not lose the effect of what I'm trying to say and the necessary detail of what I'm trying to say. It all comes with practice, and nobody's going to be good at it overnight and automatically unless they were already a lawyer or a major English major. Okay. Now, you also find that those two terms are original terms coined by me, patronate and patriciate.
They're funny.
Yeah, well, there's a reason they're funny. They're real, unfortunately.
Yep. Another term is sovereign citizen.
No, not the same thing. Sovereign citizens all have a badge and a uniform.
Oh,
There
you
you
mean
go.
cops?
Yes, I do mean cops. There you go, guys.
Yep.
I made those when I was still on Facebook.
Eddie Craig is on point with that cops being sovereign citizens.
That actually makes sense.
That does make sense.
They're sovereign by the people of the state, well, by the state, and the state
No,
sovereign by the people.
they're sovereign for the same way they define it. Cops are the only ones that truly think the law doesn't apply to them.
I was thinking too hard.
And they're true citizens by their oath. Am I wrong, Eddie?
Well, I don't know how
They're
you're
slaves,
defining
by their
true
oath.
citizen.
Like, because the citizens are the ones that are bound by the Constitution.
The citizens aren't bound by the Constitution. The government is.
Yeah.
See, that's
So
the
it makes-
thing. The Constitution doesn't govern the people. It governs the government.
Yeah.
Yep.
I was
We the
saying
people,
they-
in order to make a more perfect union, has created this Constitution. We
Yeah.
made it for the government.
I was saying they become the citizens by their oath.
Well, a citizen is determined in the 14th Amendment, which is unconstitutional to begin with. If you are foreign or naturalized and subject to jurisdiction as a citizen of the United States.
All right, guys. I'll put y'all some handmade memes in the chat if you want to look at them. But that last one, the very last one, the guy with the glasses, y'all better pay attention to that one.
It's loading.
Truth right there.
Oh man, there's no.
Verify
I mean,
the
I've heard of
information.
these terms, but oh man, gold fringe flag.
Means you got to
Yeah.
buy the balls now.
Wouldn't the proper term be, I'm not the legal person you are assuming or alleging I am? Not necessarily a corporation.
Well, okay. Legal person is accurate because the person in law, when it's talking about regulatory law, is actually a capacity. Let me give you an example. A police officer is a legal capacity. But what does that legal capacity require in order to function?
A person.
A living, breathing human being to make it functional.
Yes.
A police officer is just a title until a living being accepts the duties and responsibilities legally tied to that legal title, right?
Yep.
Well, that's exactly what a driver is. That's exactly what an operator is. That's exactly what a motor vehicle is. They are persons and devices that have assumed responsibility for a legal capacity under the law. The question is how did you assume that legal authority? Is it by
You
presumption
claimed it.
or is it by action?
Both.
Well, that depends. Are you the one doing the presuming?
No, they are.
Right. Are you the one taking the action or are they
Depends on what you meant by action.
putting on the legal capacity?
They are.
No, they're not. They can't force you to put on a legal capacity. That's the whole gist of it right there. When they say that you're a driver or an operator, they are trying to compel you to take responsibility for a legal capacity you never considered to put on and be responsible
Yeah,
for.
That's what I meant.
Okay.
They're trying to put you under it with the presumption. Oh, we're calling you this, and we're going to go with that.
However,
Even though you're.
yeah, but however, how do you take the legal action to put it on? You go apply for a license. You go register your car. You go get insurance. You are assuming all the responsibility and liability associated with that capacity of your own free will when you go do that, right? No one's forcing you, went and did it. So you volunteered yourself into the system. Now, let's split that hair into two categories. Am I actually using everything that belongs to that legal capacity because I'm acting in that legal capacity, or am I not? Now, let me give you an example of that. I go buy a hunting license for deer. Okay. Or in this case, let's back it up. I go get a fishing license, right? Now, it's not a commercial fishing license. I don't get to go out in a boat and harvest thousands of pounds of fish and bring it in and sell it to anybody. It's just a license to go fish and catch and eat the fish. I can give them away, but I can't sell them after I catch them, right? Just a regular old fishing license. Now, if I go out to a public lake stocked with publicly paid for fish and I fish, am I using that license?
I would assume so.
Well, is your assumption accurate or not?
Probably not.
I'm not asking you to think what I'm thinking. I'm asking you to decide for yourself. If you go to a public lake to get public fish, are you not using your fishing license to get them?
You're taking action in a benefit that you applied for with the fishing license.
That's correct. You're taking a benefit. Why is fishing for publicly paid for fish a benefit?
Because it's publicly owned, and
it
you
was
don't have
publicly
access to
paid
it.
for, so yes, it's publicly owned, and you're taking it for personal use, exclusive personal use, right?
Yes.
That's why you've got to get the public's permission to do it. Hence the license. Now, if you have a pond on your property and you bought the fish that went in it, do you need a license to fish in that pond?
Nope.
If you give your friends permission to fish in your pond, do they have to bring a license and show it to you to fish in your pond?
If you make it a part of a contract, maybe.
But if you just give them permission to come fish in your private pond and you don't set a condition on it, if they have to have a license to do it or pay you money to do it, do they have to show you a license?
No.
And are they using a license to do it?
No.
No, not the fishing license anyway. They're using the license of your permission, but they don't need a state fishing license issued by some state authority to do it and to accept your invitation, right?
Right.
Same thing. Can the game warden arrest me for buying fish at the supermarket because I don't have a fishing license?
No.
Okay, well, why not? The supermarket's selling the fish. They're profiting from the fish. Odds are that fish came from one of two places, nature or a farm. I don't know which one it came from. The supermarket may or may not know which one it came from. Why don't I have to have a license to buy it?
You're not using it in a commercial capacity.
What am I not using in a commercial capacity? Why can't I buy fish at a supermarket from my restaurant? I'm still using it in a commercial capacity. Does that mean I have to have a fishing license to buy it?
No.
I don't have to have the license because, once again, I'm dealing with a private entity who would be the one that had to have the license before the fish ever got to me.
I see.
They assume that responsibility, not me. You see how that works?
Yes.
That's all law is. Accepting the responsibility for some legal capacity governed by that law. It's not a straw man. It's not because you're a corporation. It's not because the Pope, the Queen, or your fucking Postmaster General said so. And it's sure as shit not because you're a state national. It's simply the law of civil society. You take responsibility for your actions, what you do, and how you do it. Okay. Some of those things are regulated, some of those things are not. The question is the regulated activity divisible from the private activity, even though they are essentially the same?
Yeah, but one has a license. You have your license plate, but you're not operating for hire compensation.
Okay. Well, let's look at it from this perspective. Let's look at it in a different kind of breakdown. You need a license to engage in a regulated activity. The regulated activity can be based upon different categories, and the categories could be because you're using the license to take a public resource for personal, private use or gain. Okay, that's why commercial fishermen have to have a commercial fisherman's license. They are taking a public fish, and it's public because it's a natural resource and it belongs to everyone, but they're taking it to put money in their own pocket and for their own use. Hence, they need a license to take from the public to keep for themselves, right?
Absolutely.
You're dealing with a private entity who themselves may be in a regulated business that requires the people they deal with to have a license. Okay? The firearms industry, they make them, gun shops sell them. Both of them have to have a license, don't they? One to manufacture, one for point of sale.
For regulation.
Correct, because firearms are regulated. They shouldn't be, but they are. All right. Same thing applies to transportation, i.e., motor vehicles and commerce. Transportation is the use of the public roads for commerce. Period. You know how I know that? Because that's how federal law defines it. And you know why that matters? Yep. Because all the states adopted that same federal law to base their law on. And when they adopted that federal law, they adopted not only the law, but all the definitions and interpretations that go with it from the federal level. Yep. So whatever the Fed law says it is exactly what it is in the state. What you have to do to prove it, it's fine where the state law specifically says it adopted the federal law. Now, there's two places that is normally located. The actual regulatory code the statutes are in, or your state administrative code, which is what creates and bestows the powers that each state administrative agency has. For instance, here in Texas, the Texas Department of Public Safety, our state police, our state troopers, they are created and empowered by Title 37 of the Texas Administrative Code. And in Title 37, Rule 4 specifically says that the Texas Department of Public Safety adopts and adheres to all the following federal statutes. And all of them are out of Title 49, the Federal Motor Carrier Safety Act. Now, what law enforcement authority does the Texas Department of Public Safety have? Traffic enforcement. That is their primary duty. Everything to do with motor vehicles and driver's licenses and motor vehicle inspections and shit like that. Registrations under the Department of Transportation, which is a different state administrative agency. But they're all tied to regulating the same devices. And all of those devices under federal law are used for commerce. So the state of Texas, whether it likes it or not, is stuck with the fact that you only have to have a license and a registered car and insurance if and only if you are engaging in transportation as defined by federal law, which is the movement of persons, goods on the land for compensation or hire for private profit or gain.
I had a question when you referred to the fishing license. So the pond is public property, yet the roads are also
No. Okay. The pond is you. The ocean is public.
Right.
The river
I'm talking
is
about the
public.
ocean. I'm talking about the ocean, right?
Well,
in
the
regards to
ocean is a natural resource. It's accessible and belongs to everyone. So anything in the ocean that wasn't put there by a particular individual is also a public resource, right?
Correct.
And each nation defines how much of their coastline that resource actually belongs to them, and you're not allowed to fish in their waters. So that's why it's regulated. American fishing ships can't go to Canada, for example, and fish over a particular imaginary line in the ocean, because that's considered sovereign territory of Canada at that point. And if they cross that line, they can get in deep shit and lose their license.
Right.
Okay.
But I guess my question is, isn't the roads public use? So
Okay. Here's the thing about the roads. The roads are a different kind of public resource. The public, there's a natural resource. The public didn't pay for it, but they are all beneficiaries of it. It exists naturally. They all can survive as long as it's intact. But if somebody takes all of it, everybody else suffers, right? That's the fishing analogy. One fishing company takes control of all the fish, nobody else gets any. That public resource is gone for somebody else's private profit or gain. No bueno. However, the difference there is the public road is something the public themselves already paid for. The roads were paid for by taxes taken from us. Okay? We paid for them. Therefore, they belong to us. And we use them as a matter of right. Not of privilege, but of right. As long as we're not using them for business.
If I may.
Yes.
In Washington RCW, it says in 46 point something highway.
Open to the public as a matter of right.
Yeah, under the definition of highway, every lane, street, highway, byway, etc., open it to the public as a matter of right.
And that's exactly the words that appear in only one place in all of Texas law, our Natural Resources Code. Now, that's a strange place to put it, considering that a road is not a natural resource. It's actually a created resource, a man-made resource. Therefore, there's nothing natural about it.
Well, I guess because there was roads back in the day and all we have done.
No, there were no roads. There was open land till somebody made a road on it, which they did by driving over it thousands of times.
I guess, yeah, right.
Yep.
Traveling.
Okay. But roads didn't occur naturally. Imprints in the ground don't appear just because. Something has to make them, right? Unless the ground's caving in.
Mm-hmm.
So those were all made by someone or something. They're not natural occurrences, is my point. But that's the code where it says open to the public as a matter of right. Well, if we have a right to it, then the state can't make us get a license to use it. That's exactly my argument against having licenses for guns. You can't license my right to own and carry a gun because the Constitution says it is a right, not a privilege.
That shall not be infringed.
Yeah, it's a right that shall not be infringed.
Yeah, and when rights are involved, there's no legislation or rulemaking that can abrogate them.
I'll be right back.
Okay, bye.
That's Miranda versus Arizona. Murdoch versus Pennsylvania says no state can take a secured liberty, turn it into a privilege, and issue a license in a fee for it. Shuttlesworth versus Birmingham says if a state does do that, you can engage in the right with impunity.
Mm-hmm.
Carl Miller.
Mm-hmm.
OG.
Some of those titles have changed since they updated and jurisprudence. Just be aware about that.
Yeah, I've looked into it.
I still don't know what's wrong on his constitutional law by Carl Miller.
Yeah,
because I was talking to Kirk Pendergrass about it. He's like, "Am jurisprudence has changed. It's the wrong citing."
Hey Eddie, I got a question for you.
Okay.
He gone.
I got a demur that I filed.
He gone.
I spoke to you about it.
No, he's back.
Oh,
Anyways, they want me to sign the Feretta waiver first, right? Or else I can't speak on it. And they want me to
Feretta
sign
waiver being a waiver of counsel.
waiver of counsel, yeah.
Okay.
So they won't hear me out until I sign my
Right. If
counsel away.
You can't act as counsel until you agree that you're not going to blame them for not having counsel. That's why you have to sign a waiver. That's what I'm saying. If you're going to be pro se, then you need to understand what that means. Now, what you can ask for is co-counsel, and you can hire an attorney to be your co-counsel, and you can be lead counsel, and then you get to speak and they get to advise instead of speak. But the Feretta waiver is, if you're going to come in here by yourself and talk to us about your case, then we want you to waive the right to counsel so you can't come back later and claim a mistrial because you didn't have it.
Right, and that's what I'm saying. They want you to sign your right to have a counsel. And wouldn't that be... Can't you retain your rights as far as counsel? That's the only way they'll hear it out, right?
Like I said, there's two ways for you to retain your right to counsel. You either hire one to act as your representative and your advocate, or you hire one that you hire as second chair in an advisory capacity only. Or they have to give you one if you get a public defender, and you can motion the court, I move the public defender be assigned to my as second chair in an advisory capacity. That's reserving your right to counsel, but at the same time, until you've done something in that regard, either waived counsel entirely or worked out something where you can have counsel there for consultation, but not for argument, then they're not going to let you talk, because anything they do could turn into a mistrial or an overturned conviction, because you can always claim I was never given assistance of counsel. And they're not going to let you do that.
Good perspective.
Right. So essentially,
is there a reason we use pro se rather than pro per?
Actually, neither of them is correct. Impropriety persona is the correct terminology for what you are. And if you don't know what that is, go look it up. Impropriety persona. In your proper person.
Yeah.
Yeah. So Eddie, would it be okay to just be like, for the purpose of the demur, just for the purpose of this demur, you want to sign?
What is a demur? And I don't mean the legal meaning of the term demur. I need to know in a general sense, what is a demur?
Objecting to the jurisdiction of the court.
It's objecting to the charging instrument.
It's a legal pleading, right?
Right.
It's one you want the court to take action on, right?
Correct.
Therefore, you're acting as an attorney filing something with the court, right?
Sure. Yeah. Right.
Therefore, you are acting as your own counsel when you file it. Hence, no waiver of counsel. You can turn around and try to say that should have never been done because you didn't have counsel at the time. There's their problem.
Yeah.
You can file shit all day as long as you've either waived your right to counsel or you've had counsel assigned in some capacity other than as lead counsel.
You can state them as stand-in, standby for you. I've had that.
Well, that's why I said second chair and in an advisory capacity.
I try to tell them that also, the public defender, but they won't even want to be a co-counsel to say this is yours.
You can't force them to act as your co-counsel even when they're a public defender.
Yep.
If you want one to sit as your co-counsel, you're going to actually have to hire one. They're the only ones that are perfectly willing to go to court and say, I'm getting paid whether I say anything or not, so here I am.
Yeah. All right.
And if y'all like those patron up memes, believe me, I've made a lot of them over the years. Because on Facebook, man, there's more moving targets than you can shake a stick at on any given day.
Hey, Eddie, I got a couple of questions if you don't mind.
Go ahead.
All right. So I'm here with my brother. His name is Sam. He's currently dealing with an obstruction charge, which is completely false. We have evidence. We have all that stuff. We're currently waiting on trial right now. I told him about this class so he can get practice for court, like on cross-examination and whatnot. So I guess the only questions I had was he has no experience other than briefly of what we've been doing for the last maybe year and a half, listening to you. And the courts are just denying all of his motions, even though he's filed all of them. And granted, we probably didn't file them correctly because we figured out who you were halfway into it. And I was like, oh crap, we probably didn't do this, or this right. But so I'm just trying to get him here for cross-examination experience, so he's not, shaking like a leaf by the time he actually gets into court.
Okay, so all right, simplify the question again. You had a lot of commentary running in there with what you wanted to ask me, so I'm not sure I got it. So just go straight up with the question here.
I want him to practice cross-examination so he can deal with the pressure in court about his obstruction charge.
Okay. Has he read the statute on obstruction? Has he broken it down like I showed y'all how to do tonight?
Yes and no. I've been the one helping him mostly with.
Okay. Well, the first thing I recommend is you read it and you break it down. That tells you the points you need to address. Now, you have to remember one thing about the elements of a criminal offense. They don't work by themselves. If there are multiple elements, all of them, every single one, doesn't matter if there's 2 elements, 6 elements, 40 elements. However many they are, they must be asserted in the charging instrument. They must be argued and proven at trial, or their entire case falls apart. They have to assert and prove every single element. If you can show even one of them is not true, the whole case falls apart, at least for that charge.
We actually have video evidence of the officer, the accusing officer, saying there is no crime here other than obstruction. But we actually have evidence, video evidence, to prove that didn't happen. Because
but what are the elements of obstruction? Does it require physical force? What do you mean there is none? Is there no?
I couldn't find the definition. I couldn't find it of obstruction in the statute. There isn't any definition.
There may not be a definition for it, but there may be a statute that describes how it's committed. What state are you in?
Oklahoma.
A rosin always completes its
One
task.
second. My kid just turned up the TV. Sorry about that.
That's okay.
I'm in the state of Oklahoma. It's Title 20. No, that's criminal procedure. Crimes and punishments is the only one I could find, and it's specific. I can quote it from memory almost. It says that a person is guilty of a misdemeanor if they disrupt or I think it's dispute or disrupt or obstruct an officer in the discharge of his duties, essentially.
All right, Oklahoma statutes, crimes and punishment.
Yeah, Title 21.
Okay. And
I think it's like 540, I believe. Give interference was the only other thing I could find was the definition of obstruction, which is a good one because that's the one I found saying that it has to be a physical act of violence or a threat, like obscene language, or that would do something. Sorry, I can't think right now. It would interfere or it will endanger the public safety or self, I believe is the definition of interference.
21-540, obstructing officer.
Yes.
Is that what it is?
I believe so.
.540, obstructing officer. Any person who willfully, there's your first element, willfully.
Yep.
Delays or obstructs. Well, there's got to be a definition for delay and obstruct. Any public officer in the discharge or attempt to discharge any duty of his or her office is guilty of a misdemeanor. Nothing in this section shall preclude a person from recording the activity of law enforcement in a public area as long as the recording activity does not delay or obstruct the law enforcement agent in his or her duties. So, what duties was the officer engaged in that he allegedly obstructed?
A damaged bumper.
Whose
Stop.
damaged bumper?
He claimed it was a motor vehicle. It was the Samuel, my brother. He was traveling in his car.
Okay, not my point. Whose vehicle? Your brother's or someone else's?
Someone else's.
Okay, so someone else made a complaint that your brother damaged their vehicle.
No.
Okay, then explain what the damage part of this has to do with it then.
It was an out headlight.
They pulled him over for, he originally was a damaged bumper, damaged equipment, such as a missing headlight appearance.
On his own car?
On the car he was traveling in. It's owned by a trust. Our parents own the trust, and he was traveling in it, so he has access to it.
Okay. So it was a private car. Go ahead.
Yeah. Go ahead, Sam.
Yeah, they had pulled us over because one of the headlights was out. And that was the reason why he had pulled us over. And then after that, he continued with asking for the driver's license and registration and so on. And I didn't give it to him because it's information protected under the Fourth Amendment. And then he continued
about that?
Yes.
And how are you sure about that?
I can't quote it off the top of my head.
What kind of information is protected under the Fourth Amendment?
From the knowledge that I have right now, specifically just protected personal information like name, date of birth.
Where does the Fourth Amendment say that's protected personal information?
I don't have the.
What is the criteria for the Fourth
Amendment?
Amendment? Search and seizure, right?
Unreasonable search and seizure.
Right. Unreasonable. That is your operative word right there. If they consider you engaged in a regulated activity that you cannot immediately rebut on the spot, the presumption is valid. Therefore, the action is not unreasonable. Now,
this was a traffic stop, right?
What?
This was a traffic stop, right?
Yeah, but let me finish the thought process here.
Okay.
By the same token, if you'd been sitting at Burger King, eating dinner, doing absolutely nothing that could be considered a regulated activity, and you'd been there for an hour, and they come in and start demanding to know who you are, seizing your ID and seizing you and all that, that would be unreasonable because there's no basis for it. There's no articulable facts in support. If there are articulable facts, even if those facts are incorrect, but the officer believes them to be accurate, then what he's doing is not unreasonable. Now, since you brought it up, you said they stopped you for a headlight, right?
Yes.
So what does state law in Oklahoma require when it comes to vehicle equipment relative specifically to headlights? And let me tell you why we're asking this. Helen, the other person, one of the other people in this class, has a case on exactly that issue. She was illegally detained and arrested because the cop pulled her over for having only one working headlamp. Okay, exact same scenario. However, when you read the Texas statute does not require two working headlamps on a car. It only requires a working lamp on either side of the front of the car. And the statute very clearly says when it's talking about a headlamp and when it's using the term lamp to speak generally of any light on the car. So when you read it, technically what it says is you must have some kind of glowing fucking light bulb on either side of the front of your car. Doesn't say it has to be a headlamp. Doesn't have to say either of them have to be a headlamp. But the one criteria that must be met by those glowing lamps is that it makes your car visible from a distance of 1,000 feet. So it has to be bright enough for that. Well, one headlamp can do that. You can see a candle at a mile on flat ground. That's a candle. So a headlamp on a car is most assuredly visible at 1,000 feet, as long as you got line of sight. Okay, so that's the thing about the statute. That's exactly the problem. So what you need to do is stop arguing over the reasonableness issue, because until you can show that there was no violation, which would in and of itself make the officer's actions unreasonable, then you're kind of fighting a very hard to win uphill battle. You get me?
Yeah.
Okay. So the first thing you need to do, in my opinion, is go find the statute on headlamps and see whether or not the statute specifically says there must be two and they must both work.
Well, at the point of this, he's headed for trial. They actually dismissed that one, and they're just sticking with the obstruction charge.
Well, but the obstruction charge is based upon the first charge, right?
Assumedly, they charged him. I think they only charged him with just the one.
The first charge was a defective vehicle. And then when the very first court date that I went to, they dismissed that charge and they only have the obstruction charge now. That's the only thing that's there.
But again, the argument is the obstruction charge tied solely to the first charge?
Yeah.
If the first charge didn't stick because it didn't exist, that makes the stop illegal. If the stop was illegal, there's no way you could commit obstruction because the officer was not engaged in any lawful duty. The cop can't be committing an illegal act and also be engaged in the discharge of his duties, because his duty is not to commit illegal traffic stops. Right?
Yes.
Yeah.
This should be void ab initio.
If the reason the charge was dropped is because there is no such valid charge, then you need to make the argument the obstruction charge cannot stand by itself because the officer was acting illegally at the time and therefore could not have been engaged in a proper lawful discharge of his duties.
Okay, but they did dismiss the charge, but the headlight was out.
To figure it doesn't matter if it was out. If having only one headlamp is not actually a violation of the statute, then the charge and the stop were both invalid. Hence the reason it got dismissed. That's why you need to read the statute to see if that is potentially the case.
So if that's the case, then it doesn't matter how many headlights there were on. It doesn't matter.
Again, if the statute doesn't specifically require two, okay, that would have made the stop illegal.
Yes.
Okay. The officer cannot claim obstruction for his illegal act. Okay.
Yeah.
There was nothing to obstruct.
There was no discharge of a valid duty to obstruct.
Don't they have to give a reason for dismissing the first charge?
No, they don't. They can just say in the interest of justice, which is how they usually say it, so they don't have to admit how badly they screwed up.
So
and you have a record of it.
Yeah, so if the initial charge is dismissed, then how could they have a leg to stand on for the second charge?
He's going to trial in a couple of months.
There's not always a joint at the hip situation. If the officer was acting reasonably and within the legal part of his proper duties, and he didn't cooperate, then it wouldn't matter if they dropped the original charge and stuck with the obstruction. He would be hit with obstruction and it would be valid. But if what the officer was doing was not reasonable and was not a proper duty for him to be engaged in, then he can't be obstructed in doing something that on its face was illegal.
So couldn't he file, or couldn't, after he looked up their specific statute on it and he finds that it was unreasonable, couldn't he file a motion to suppress the stop?
Well, there's nothing to suppress. The stop's no longer relevant. What's relevant is the obstruction part. So the argument has to revive the stop charge long enough to say all of this up to this point was invalid. I should have never been charged because I should have never been stopped. The officer conducted an illegal stop, and no reasonable officer, having read the statute, would have made that stop. Therefore, the officer was not acting reasonably. If the officer was not acting reasonably, he was not acting in the proper discharge of his duties. If he was not acting in the proper discharge of his duties, I could not have obstructed what is on its face an illegal act by the officer.
All right.
You're charging me with obstructing the commission of a crime. How's that an offense?
All right.
Yeah, because he wasn't in his lawful duty if it's illegal what he was doing.
Correct.
Well,
he was also not engaged in transportation either.
Well, then couldn't he
that would have been an argument. That would have been an argument for the equipment issue, not for the obstruction issue.
Well, then couldn't he file a motion to dismiss based on that?
He can file a motion to dismiss based on what I just said.
Yeah, that's what I meant.
Could I even still do that right now since the court is, or the trial is the next court date I have?
You have to do it within a certain time frame.
No, if he makes a challenge to jurisdiction because there is no valid offense, and he makes the argument where the court has to agree with it, then because subject matter jurisdiction can be challenged at any time, even after the trial's been had.
Right.
We already filed a subject matter jurisdiction challenge and they dismissed it.
Eddie?
Yes.
Can you still challenge the subject matter if you paid the fine?
Can you challenge the subject matter if you what?
If you paid the fine.
No.
Okay.
Well, yes, you can if you can prove the subject matter never existed.
Okay.
But when you're talking about a transportation related case, paying the fine is putting on the legal capacity that goes with it. And by accepting that duty, you can't say that jurisdiction didn't exist. They're mutually exclusive. Okay. If you took the legal capacity, you gave jurisdiction, no matter what. Because you stepped into that role and the court has jurisdiction over that role.
But pleading not guilty does not admit jurisdiction.
That depends on which kind of jurisdiction you're referring to. It does not admit. Subject matter jurisdiction is the only jurisdiction that cannot be waived or presumed. It must be proven. Personal jurisdiction can be very easily waived. You can waive personal jurisdiction by opening your mouth to say anything other in court before you say, I hereby challenge the personal jurisdiction of this court. Okay. If you don't reserve your right to challenge personal jurisdiction, the very first thing, then the appearance you're making is not protected. It is general. And if you make a general appearance, personal jurisdiction has been waived. Period. And you will never, ever get it back.
Okay, so what's his? Let's say we find a statute and it doesn't apply. He has court in October 8th, like trial. He has trial October 8th.
Well, if you're forced to go to trial based upon what we produced out of this discussion, and it turns out that the statute says that the stop itself was invalid and unreasonable, then what you need to do is get that into the record during the trial. For instance, officer, you originally charged me with another offense. What was that offense? Well, it was blah, blah, blah. Okay. Vehicle, equipment, or whatever. And that charge was dropped. Do you know why? Now, he may or may not know why. Okay. So you've got to have that answer before you ask that any kind of question like that. You've got to know why that charge was dropped. And the only way you're going to do that is to question the prosecutor, but only after you understand the statute. Because that way the prosecutor can't bullshit you one way or the other. If you know what the statute says and you know you were in the right, then the prosecutor can't bullshit you to say, well, I just dropped it, so I didn't have to worry about it. Well, I had this one anyway, and it's a bigger offense, and I didn't worry about the little shit. No. You had no case to begin with because the stop itself was unreasonable because it was illegal. The officer didn't understand the law and he misapplied it. Now, granted, courts have said if the officer thought he understood the law and thought he was acting reasonable, then he's covered. But that doesn't mean it's true everywhere. That's only true in certain states under certain courts. So don't assume that that's how it'll work in your state until you try it. But once you start to make that argument, I highly recommend you find a law library at a local university or something, get some help from the librarians or your state law library if you're close enough to a major city that's got one, and go in there and talk to the librarians and ask for help, saying, look, I need to find out if there's ever, and most of them will have computers set up to get on LexisNexis and look up case law. They can't do it for you, but they can certainly help you look it up. And you'll go and look up for any cases that refer to that statute. Okay? The headlight statute, for instance, are dealing with the keyword of reasonableness and mistake of law, et cetera, et cetera. And you find cases on that. And then you try to find any of them that will help you and hurt the other side, but make sure you shepherdize them, which means you check and make sure they're still good law.
Not overturned.
Not overturned by one of the other decisions the other side's liable to be quoted that disagrees with you. Hell, they may even cite the same case you do, but just a different part of it. So make sure you read the whole thing, not just the part you think you like.
Good point. Cherry picking.
Yep, don't do that. Read the whole opinion and understand it.
We got a lot of research.
Yes, you do. All right, guys. I'm way past my usual due time here. We're almost 2 hours over. So I'm going to get off here. Thank you all for coming. And we will be here next week. But we will not go 4 hours next week. Don't count on that because it ain't going to fucking happen.
Oops.
All right. So
Appreciate
have a good night. Thank you all for coming. And hopefully you found it worthwhile and we'll come back again.
Yep.
All right. Appreciate it.
All right, y'all.
Have a good night, guys.
You're a beast, man. Later.